hope to ask you a question.
You start with you.
Assalamualaikum. So I'm Salina. My parents are here. They also come to Musalla quite a bit. So I primarily do immigration. The reason I got into immigration was because when I was young, about 6 years old, my dad, he did a lot of work with the Rohingya refugees in Bangladesh, and that's really essentially what piqued my interest. And I think shortly after law school, I got involved with doing a lot of asylum and pre-immigration. So pre-immigration is like the branch between criminal law and immigration. It doesn't impact our communities as much, but it does impact other communities. Immigration is very interesting because there's a lot of intersections between immigration and other branches of law. I don't have much else to say.
Assalamu alaikum wa rahmatullah. I'm Yusuf, also known as Joseph Jarudi, and as the Sheikh mentioned, I primarily practice inheritance law, but as well as business law and real estate as well. So happy to inshallah share some good information with you today and answer some questions.
Assalamu alaikum. My name is Noor Al-Baba. I have been licensed to practice law in Texas for about 15 years now, but I've been practicing exclusively family law for the past, I would say, 7 years or so. So family law is what it sounds like. It is the law that affects family situations and relationships, which includes divorce, child custody, adoptions, and within that is also, child support. And so those things can be litigated together or separately. So I'm here today to give you an overview of what family law in Texas looks like, because it varies pretty vastly from state to state, and to answer any questions you may have that I can.
So, as I mentioned, immigration is interesting. It's actually federal. So you can actually have an attorney anywhere in the U.S. They don't necessarily have to be where you are. The only times it matters as to where your attorney's license is if you have like a family issue, or if you have like a criminal issue or one of the state issues. So for example, let's say, you have issues with DUI. Now, whether or not that's going to affect your immigration is going to, obviously depend based on the criminal codes of that particular state. So that's the only time where your attorney is situated matters. And then the other times that, it matters where your attorney is if you need to go to like, if you need to go to various, they have a lot of interviews, and then also court. Court usually doesn't come into play that much in immigration unless you are essentially in one of the defenses. For example, if you're an asylee who has been asked to essentially leave the States, or if you have a lot of criminal issues and you're you're about to get deported. So that's the only time where, for immigration at least, court comes into play. The other times it's usually just filing your cases and knowing how to file those cases. And then the other interesting thing about immigration is it literally is an alphabet soup. They have visas from essentially A to Z. But the ones that impact most communities are the family law ones, the family-based immigration, which is essentially if you're applying for your spouse, parents, siblings, etc. And then the other ones that affect a lot of the communities are student visas and employment visas. Those are the primary big ones, but then also there's asylum. Sorry, anybody have any questions before I continue?
Let me ask you a question regarding you mentioned that our countries, most of the people, they know that you are here, you want to come over here, and you get to get a sponsorship for a green card or permanent residency. What is really the obligation? You just try to do it for a favor, But what is the real obligation toward that person until he gets the citizenship?
You're actually financially responsible for them until they become a citizen. So,
Salmina, could you repeat the question so
Okay.
everyone can?
sorry, he was asking if somebody's sponsoring a family member, what is their obligation? So the obligation is a financial obligation that you have. So essentially, for example, if they decide to go and take food stamps. Now you're actually liable for paying the government back or something like that because they're not supposed to be on food stamps or something like that nature. If they can't, I mean, we rarely ever see those issues. And then the other times it could be impacted is, for example, let's say you sponsor somebody and that person gets divorced. The other party can use your sponsorship to then negotiate a family law deal. And I'm pretty sure Nura can talk more about that, how the I-864 can have an effect in divorces and settlements like that, right?
I have not experienced it.
Oh, okay.
So I'm sorry.
Okay, so that's been something kind of been circulating recently is they can use the I-864, which is the sponsorship agreement, the financial sponsorship agreement, and it can be used in divorces to some degree. But that's more of a family law matter. Does that answer your question?
I mean, but do you have the right to terminate the sponsorship?
No, you're actually liable until they become a citizen. Sorry, the question was, do you have the right to terminate? No, you can't actually terminate until they become a citizen. You are on the hook until they are a citizen. Or they get deported. Either or. But if they're in the country, you're responsible for them financially.
So we have another question. What's the best practice to apply for a green card as a student?
So, okay. What?
They're mixed, but I'll tell you overall. So we have some questions coming in online. It says, what's the best practice to apply for a green card as a student for Salmina?
So you actually can't, I mean, there's no direct pathway to apply for a green card as a student. You essentially have to go through either employment law. You either have to go through like the employment law process or a family member has to sincerely sponsor you. So through employment, they have things such as, H-1B visas. They have several different types of visa. H-1B is the more common one. And then sometimes as students, you can still take on externships and internships, but you have to be very careful because if you're going to go on CPT, that's the curriculum practical training, you can actually work up to a certain amount of time depending on your school, what your school allows. It's usually part-time. But if you go on CPT, you wouldn't really be able to go and work after you graduate and have that opportunity to then get sponsored by an employer. In some cases you can. So that is an option, but a lot of people sometimes do get into trouble as students when they're taking particular classes that have a practical training portion and they do not realize that they're supposed to be on CPT. And so they can actually get in quite a lot of trouble. So it is always important to make sure that if you're going to take even classes, as if they're practical-based classes, you have to get it. Either you read the student handbook, or you have to be working with the international office to make sure that you're not going to get in trouble.
As pro-Trump, has a pro-Trump U.S. made it difficult for people seeking asylum for Salmina?
Not just asylum. The pro-Trump administration really did slow down, well, the Trump administration really did slow down immigration. Not only that, so it's not just the person in the presidency that affects immigration. It's also your congressional members that impact immigration. So for example, if you, in certain cases, such as the whole situation with Ukraine and Russia, wherever they had immigration sympathetic congressional members, we were able to get those cases expedited. We were able to get, the fastest case that I saw with the congressional help was, we were able to get them here in 3 months, which is super fast for immigration. But So it is extremely important that when you are voting, especially now that it's primary season, that you do keep in mind, because it is extremely important to know what their policies are as far as immigration. Does anybody have any other immigration-related questions?
I have a question regarding wasiyah.
That's next.
Okay. Some other topics that I kind of wanted to quickly go over as far as immigration. There are two main types of visas. There is the non-immigrant visas and immigrant visas. So non-immigrant visas means that you're applying for visas that are temporary in nature. Even though, when they say temporary, they don't mean like 3 months. Temporary, like the student visa, you can have a student visa, even up to 7 years or longer in some instances. But non-immigrant visas essentially mean that you are not coming to the U.S. as a permanent resident. You're only coming here for a certain nature and duration. And then immigrant visas, such as the ones that we apply for our families, those are, those immigrants are coming to the U.S. In permanent nature. And you can have an immigrant visa even through employment as well. So those are the two distinguishing. And then the other thing that's different also is you have to keep in mind the difference between adjustment of status and consular processing. So adjustment of status means you are here in the U.S. and you're going from a non-immigrant visa to an immigrant visa. And consular processing essentially means that your visa application part of it is going to be processed in the U.S., but the interview portion and the other processing has to happen in the foreign country. If no one has any other specific questions, I'm going to go ahead and start.
Bismillah, alhamdulillah, wassalatu wassalamu ala rasulillah. So this third of the panel will be about inheritance law, both before the fact and after the fact. So before the fact, meaning planning for, doing the trust, doing the will, doing all of that good stuff, and then after the fact, meaning distributing the assets. So, I have some questions here, so I can address those, but I still want to just give a small overview. So, as we know in Islam, when you pass away, your assets have to go to specific people in specific percentages. You cannot give everything to one child when you pass away in a will. You can legally, yeah, but Islamically, that's haram, right? Yeah. Okay. We have the okay from the Shaykh, so it's haram. So, and if you give everything equally, also haram. If you give it to one spouse only, incorrect. So these are very dangerous. You need to be very careful, right? Very careful. There's a few things I'd like to mention. So if you don't do a will, or you don't do a trust, or you don't do something, the state of Texas is going to say who gets what. And a lot of times, it's all going to go to your spouse, and your children not going to get a thing if it's community property. So if you don't do anything, everything that's community property, which is likely almost everything sometimes, depending how long you're married, is going to go to your spouse. Everything going to go to your spouse. What if she or he remarries somebody else, and then she passes away, and he takes everything, and so what happened to your kids, right? So now your kids got cut out of the equation. That's very, very dangerous. Not to mention, it's not halal, obviously. So what to do? I would strongly recommend anybody here have children, whether they're married or not, doesn't matter. Whoever here has at least assets of any kind, schedule a time to speak with me. We'll take 45 minutes and we'll go through the consultation. Now, a lot of people think, a lot of people are wondering what goes inside of a will. So inside of a will, you simply say who gets what. So you're going to say the Islamic percentages. You're going to say my wife gets, for example, 1/8. My mother gets 1/6, for example. My son, this certain percentage. My daughter, this percentage. Right? And if it changes, you say if anything changes and I did not get a chance to update my will, then my executor is going to go and update the percentages. That's fine, but I want it to go Islamically. If you don't do it, it's not going to go Islamically. Texas is not going to let that happen. So I've, alhamdulillah, been working on this will for 5 years now. And I've been talking to the scholars, alhamdulillah, refining my language. And I've been reading many books and many texts, legal and Islamic texts to help further this, okay? So that's what goes inside of a will. A will also, you have to name an executor, somebody to manage the distribution. So, who, if you leave kids, who's going to be the one to handle all of this? So you have to name a plan A, and if plan A is not available, plan B and plan C. So that's what goes inside the will. Now here's a big curveball. Here's a very big curveball. Everyone thinks only about who gets what, but no one actually thinks about what property are you going to distribute so when one of the spouses passed away. Say there's a husband and wife, okay, and there's a savings account in his name. Now, is the whole account supposed to be distributed, or is only half? Did his wife own a half? So how do we know? We have no clue to know who owned what percent of what asset. The house. What if she contributed, 70% of the house? Islamically, she contributed 70%. She put money in the house. And now, when he passes away, now all of a sudden, you're going to distribute half the house, 50%. You're going to distribute some of her money. So there is some gray area, who owns what of each asset. And if you don't write it on a piece of paper, no one's going to know. No one's going to know. And the default rules of Texas, take everything, cut it in half, and distribute according to the will. What kind of, this is crazy. Meaning, if I pass away, I have a will, okay, Islamic will. I give 1/6 to my parents, 16.6 to my mother. Now my wife she's working, alhamdulillah, she has a savings account. You know what's going to happen when I pass away and I have an Islamic will? Half of her savings account is going to go to my mom. She's going to take 16.6% of my wife's savings account because it's community property, because it was acquired during the marriage. And that's crazy as Muslims. So the workaround, there's two workarounds. Number one, and there's two workarounds. One of them involving your spouse to agree with this workaround. The other one involves you're not working with them. You don't have their signature, and it's not guaranteed. The guaranteed workaround is not only you do a will or a trust, but you do a property agreement. A property agreement. So now the whole thing got more complicated. Not only you're doing a will or a trust, you're doing a property agreement. Also known as like a prenup or a postnup, marital agreement, whatever you want to call it, you do that. So I highly recommend that to make sure that your will or your trust is enforceable. Or else, you think you're doing something Islamic, but actually it's going to affect all the other assets. You're going to be distributing some of your half of your wife's stuff to your members of the family in inheritance because you didn't know. So again, don't fill out those forms from the websites. That is actually not going to get you where you want to go. You want to do a property agreement with the will. Now that's plan A. Plan B, the second option is to do the will, and your wife do a will too, and to say in there that my wife and I we've discussed and we want to give away everything Islamically without the need for a property agreement. And my will is going to give away, for example, say I pay for the house. Okay? I paid for the whole house, like in my situation. My wife did not put anything in the house, but she owns 50% legally. Nora will tell you, community property, she owns 50% of the house. But in my will, I'm going to say, I'm not only going to give away my 50% of the house, I'm going to give away her 50% of the house too. We didn't do the property agreement, that's why I'm saying that. So we're going to give away the whole house. And the only way that will work is if she voluntarily consent to my will. And she has the power to contest my will and to actually keep her 50% of everything. So it's not airtight. If you don't do the property agreement, it's possible. It's an option, right? If everyone's all in agreement, singing Kumbaya, okay, that's going to work. 2 wills, everyone's happy. But if you do 2 wills on a property agreement, it's much better, much more enforceable, and you make sure your estate is given, Islamically especially, how much, or you specify how much of each asset you own. There's a lot of other things you put in the will. Funeral instructions. I had once, family members, there was converts, non-converts, they were arguing, should we cremate the person or not? And eventually the guy was unfortunately cremated. That was a big deal because he didn't have a will that said how he wants to be, buried Islamically. And then also you say guardian for your minor children. That goes in the will too. Payment of debts. In the Quran it says no one gets inheritance until what? Debt is paid and gifts are given. You give the gift, a bequest. So you give a gift to the masjid, for example. Then the inheritance gets distributed. First you pay debts, then you pay the bequest, the gifts, to say your friends or a school. Then you distribute the inheritance. So that's why you should have will. Without further ado, I think that's all I have to say. Let's see some questions.
I have a question.
Yeah, go ahead.
You answered the basic question that I had. If I go through the complicated plan A and B that you mentioned, and everything is on paper and everything is signed and agreed on by all parties, would that signed papers take precedent over the fact that the house is, the deed is written by the husband and wife, the bank account is, husband and wife, beneficiaries are stated by name and percentages that are not Islamic.
Yeah, you need to change the percentages. You have to change the percentages. That's something else. But yes, it would take precedence.
Okay.
It's a very powerful agreement. It's very powerful. The Texas Constitution gives you the right to do that. You can eliminate community property altogether.
So that takes precedent of anything that has been documented.
Absolutely, but you need to change a few things along with the agreement. For example, you said the house is in 2 people's names, right?
Yes.
Okay, and then you do the agreement, you say it's all yours, right? Because you paid, right? Say, for example, you want to, in the agreement, say the house is not 50-50 like in Texas law, it's mine all.
Regardless, we're gonna make a Islamic will
Right,
that all parties agree on.
right, but who owns the house? Tell me. Who contributed to the
I don't
house?
want to get into details, I'm just,
Right.
let's talk generic.
Right,
Okay, so you confirm that these legal papers are going to take precedent over whatever written in the deed, whatever in the bank account, whatever beneficiary is stated in the retirement plan. These are
Yes,
the-
but-
the solution.
it is a solution, but you have to follow through with a few things. So it's not a 100% solution. So if you say, we have to get into an example, we have to say one detail at least, right? So one detail, say the house, we made it all yours. So then we have to follow up after the agreement and we have to do a deed where she gives you her half. Just small things like that.
So basically, it's still after death, we need a lawyer to take care of this stuff, right?
Absolutely. It's called
Because,
probate.
I have papers,
Yeah,
but I don't know what to do with them, right?
absolutely. Absolutely. That's half my crap.
So after death, not only should you consult a, trust and wills attorney, you should also consult a tax attorney as well, because there are also a lot of tax implications related to inheritance and even for the executor.
Absolutely. Yeah, so not only lawyer, but your CPA or a tax lawyer or what have you, that's definitely for the tax implications. So
you can't have like a general word saying, I would like my wealth to be distributed Islamic in an Islamic Sharia. Just a general,
I don't
because
think so. I don't
it's
think
going to be like a yearly basis to update it based
don't
on
know.
whatever changes happens.
yeah, but the problem is your will only gives away 50% of your community property. 50%. Your wife owns the other 50%. So unless you list every single thing and you specify that I want to give not only my half but her half of my car, my house. And not only that, she has to agree. When you pass away, she has to agree that this is going to be the case because she has a right. Yeah. I researched the case law. I looked at all the cases and,
Are you saying she might disagree after death?
absolutely, unless you have the property agreement. And even so, she can try to disagree a little bit, but not as much, inshallah. Inshallah, it'll be fun.
So the husband is always on the losing end.
Yeah. Yeah. Yes.
Let's say you wanted to give according to Islam, okay, like 1/16 your wife and rest is like a boy girl.
Yeah.
And if a wife said no, put everything me, if I die then I'll do that. Is it legal to do that?
No, she can't tell you how to do your will. You can say whatever you want in your will. Okay?
But if I listen to her, will it be safe? I mean, would it be against Islam? Just give everything to her?
Yeah, that's
then-
not correct. You should not listen. If your wife says, no, give me everything, no, don't listen to that. That's against Allah. Azza wa Jalla.
Okay, the same question. If let's assume like we have a wife and 3 kids, 2 boys and 1 girl.
Uh-huh.
So they are all agree on Islamic law, but I want to, they agree that okay, let's distribute amount equally.
No.
Is it allowed?
No.
Can you repeat the question?
Oh, yes, thank you. So he's saying, okay, I have kids and wife and everything, but everyone agrees that we want to give equally to the children, right?
Yep.
Not double, the son gets double the daughter. You can't do that. You cannot agree during life. They can agree all of that after you passed away. They can do a settlement agreement after. Okay? Because right now they have certain feelings, but when you pass away, they're going to feel different. And they might change their mind. So it's their haqq. Yes?
I have Medicaid insurance.
Medicaid, you have
So
Medicaid.
they are covering my health insurance. If I pass away, then they take all the expenses they spend it on me from my wealth, like property or car or anything else.
There's actually, they can become a creditor, they can, but it's a lengthy process, but most likely that will not be the case. So, but I would have to look at your situation specifically. But most likely, inshallah, you want that. They're a class 8 unsecured claim, so. Yes, brother.
How do trusts play into Islamic law?
Trust, great. Okay, this will be the last question. I kind of want to give to Noor and not keep you on this long. So trusts versus wills. You know, in Islam, if you give away, if somebody is non-Muslim, your son becomes non-Muslim, ma'adallah, or a wife becomes non-Muslim, ma'adallah. Do they inherit? Well, the answer is no, and the Sheikh's here to confirm, right? So they don't. So that's a problem, right? Imagine the judge looking at that in your will and going like, what's going on here? Like, it's going to open some eyes with the judge. So that's why I'm starting to recommend, actually, the trust keeps things just a little bit more private. So that's why trusts are actually recommended. Keep things a little more private, have more control. But again, I think both will work, inshallah. If you do a trust, it's more expense now, less expenses later. Okay? More now, less later. So right now, for example, you're going to pay like a lot of money to do a trust. But if you do a will, you'll pay a little bit of money now and a lot of money later. Okay, so it's flipped. But the trust, just keep in mind, you're going to have to put everything inside of your trust. Your house, you have to deed it inside of your trust. Your bank account, put it in your trust. Put it in the name of the trust. So you have to put things inside the trust. You can't just make it and forget about it. You have to fund the trust. Okay? But yes, it's an option. Definitely, definitely.
Maybe you may have to explain what is the difference between the trust and the will.
Okay, so a trust is when you give something to a third party for the benefit of somebody else. So for example, it doesn't even have to be written. I can give you right now this microphone, and I say, here you go, brother. This is for you. Please keep it and give it to your son after 10 years. That's a trust. Giving something to somebody else for the benefit of a third party. That's what a trust means. And the terms of a trust is a document called the trust agreement. Okay? And that's where you put, all the details. The will is just a document saying, this is how my stuff goes. But a trust is a different animal.
Does it have a name in Arabic?
A trust, does it have a name in Arabic, Michelle?
What is it? Amana?
Amana is in Arabic, amana. What about waqf? Is that something?
Endowment.
Endowment? Okay. All right, so amana. So it's almost like an amana.
So trust is more powerful than the will.
Not powerful, it's just more private.
Okay.
Yeah. It's
Private
more
as in what?
private as in eyes of the judge and eyes of others looking into your business. Because when you pass away with the will, you have to go to the court. You have to go to the court with the will. You have to give them the will. You never get it back. They have a library of like 1 million wills in the courthouse. Yes, I saw it.
After death, you give the will to the judge
Yes.
to implement it.
No, it's just so he's safekeeping. You implement it. Your spouse or whoever you name as executor implements it. Yes.
So why am I giving the will to the judge?
That's the law.
That's the law.
That's the law.
And trust, I don't have to give it to him.
No, trust you don't give it to him. Trust, and once you give it to the judge, by the way, the will, it's public. Public. Everyone's reading it and all of this and that. And you have to file an inventory to see all of your assets, A to Z. So right now, I think George H.W. Bush passed away in Harris County. You can go to his case, look at his will, and look at his inventory maybe. Anyways, but the trust, no, none of that happens.
So you're saying the will should go through the judge?
Absolutely. I just had one last week. The guy did a fill in the blanks Muslim will. Alhamdulillah, went through. I was like sweating bullets. He said, man, they put the wrong names in the wrong blanks, and they forgot the very important word. It was not notarized correctly. One of the witnesses was missing. It was missing a leg, missing an arm. Alhamdulillah, the judge was feeling happy today, and she said, granted. And so now we're okay, Anyways. But yeah, so what I'll do, I'm going to open my laptop, I'm going to have a QR code, and then you just scan the QR code and you can make an appointment like that, okay? And so you just, there's a small consultation fee, just in case you don't change your mind, at least, it was worth it. So.
One question here. If I have already trust and went from in a different state, I just moved here like a few months ago.
Yeah.
Do I have to update it? Do you have?
I recommend you update your will.
Can you have it in both states? Like, because part of my family still live there and I live here.
Yeah, but regardless of, so you're saying if you have a will in a different state and then you moved here, but his family's still there.
Mm-hmm.
It doesn't matter where your family is. This is your will. Where are you living? You moved here.
But part like I still have house over there, so.
But where do you?
Property.
But where's your domicile? Where do you permanently are going to go back to? Is it there or here? Where do you call home?
For now, I'm here.
Or now you're here. So
Yeah.
I recommend you update. That's my recommendation. So.
So one last question.
Yes.
As Muslim, what should we do? Will or trust or both?
They both get to the same objective, and as a Muslim, that makes me feel like it's a Sheikh question. You have to Sheikh will or trust?
The trust is safer.
Sounds safer, right? The trust sounds safer because you have more control over the process. You won't have a judge in will contests and stuff like that. But inshallah, trust sounds safer. Although both are halal, actually. Okay.
Will can be part of under the trust, right? Can you put the will under the trust or no?
You need to have, actually, if you have a trust, you need a pour-over will, which is if you forget anything to put in the trust, the pour-over will says, anything I forgot goes into the trust. You know, so you just have to. Don't worry. I mean, you're not going to have a will inside of the trust. No, they're separate documents. You'll have
They're
both.
separate, but
They're separate.
my understanding, yeah, they were separate, but my understanding it is under the trust. Like, trust will involve everything, it's not, but will not cover the trust, right? Like, my understanding was like trust is like a bucket and you put everything there in that trust.
Oh, yeah, put it in the trust. Except your will. I mean, you can't put a will in a trust. You can put a trust in a will. Maybe that's what you're thinking of.
Maybe.
It's called a testamentary trust. You can put a trust inside of a will. We can have a talk. No problem. If you want. All right, it's all yours.
Assalamu alaikum. So I mentioned earlier the topics that family law covers, but I'm going to specifically talk about divorce, this limited time that I have, and the process in Texas, how it goes, and some issues that I've seen commonly arise in our community. So whether or not a divorce is agreed upon between the spouses, say that you've decided you both want a divorce and you don't think there's many issues in dividing your property and everything, regardless, you still have to file a petition with the court in order to be granted a divorce. Either spouse can file a petition. There's really not an advantage or disadvantage from one spouse filing or the other, except that the filing spouse pays the filing fees, which are negligible, $250, $300. Other than that, not one spouse or the other is not put in a compromised position because they didn't file first. You're seen as equal in the eyes of Texas law. After the petition is filed with the court, then the petition has to be served on your spouse. Now, if you and your spouse are already in agreement with the divorce, know that it's happening, know that it's coming, then you are able to execute something called a waiver, which is just paperwork between you, and it's kept more private, and you file that with the court. However, if it's not that situation, then you will have to have a process server. It could be a sheriff, or it could just be a private process server company who will physically take the petition and have to hand it by hand to the person that you are serving, and that way that they have notice that you have filed for divorce. After your spouse has been served, then they have 20 days, specifically the first Monday after 20 days, in which to file an answer to your petition. An answer is simple as, I have responded. I mean, it's a legal document, but it's basically saying, I have received this and I am answering, meaning I don't want anything to happen without my consent or my notice. If you do not, it's very important that you do file an answer, because if you do not, it is very possible and very likely that your spouse will go ahead and obtain a divorce and whatever they want in the divorce document, the divorce decree, without your consent. Okay? If they can prove that you have actually been served, and you have not responded in the correct time, then they can get something called a default judgment from the judge and say, not only am I divorced, but I'm going to take whatever I want, specifically say what you want, and even with the children and everything, and they will get it if they can prove that their spouse was served and did not respond. So once, say that a spouse has been served and they file their answer, the next step is usually courts here in Texas, especially Fort Bend County, Harris County, Montgomery County, the judge will require you to go through mediation, the first thing. Mediation is an informal process in which, ideally each spouse has hired an attorney, although it's not required. You could definitely represent yourself in a divorce in any kind of suit in Texas, but in a divorce petition, you don't have to have an attorney, but it's highly recommended. The two spouses will have a mediator. They will sit in separate rooms always, you will never be together. And the mediator, who is usually a licensed attorney or a former judge, somebody who's familiar with family law, will physically go between the parties and negotiate between them as to what they would like to see come out of this divorce. And that can apply to property issues, assets that the spouses have, as well as child issues. So So if you have children of the marriage who are under 18, they will have to be addressed in the divorce. And by addressed, that includes both child support issues as well as child possession issues schedules. Briefly to go over that, child support in Texas is something that is required, usually of the obligor of the child support, meaning the person who has to pay the child support, will be paying it to the spouse who has primary custody of the child. Primary custody usually means that they are the parent whose residence determines where the child is going to go to school, and it's usually the parent who has the child for the majority of the time. And by majority of the time, I mean that in Texas, a standard possession schedule. So by standard, I mean this is what Texas will give you if you do not agree. You can always agree in a divorce on whatever terms that you want, as long as the court sees it as being in the best interest of the child. Generally speaking, you can agree to almost anything. But standard schedule in Texas is the non-primary parent, okay, will have, or the non-possessory parent will have the child or children the first, third, and fifth weekend of every month, usually Friday evening till Sunday evening, as well as once a week, every week on Thursday evenings for a couple of hours. That's just standard, but again, you can agree to anything that you would want to or both spouses feel comfortable with. And that agreement can be made in mediation. As far as property issues, Texas, as Joseph mentioned, is a community property state. That means that any assets acquired during the marriage, so from the day that you get married and onward, are theoretically 50-50 between the spouses. Now that is not an exact division. That is not exactly 50%, doesn't always work out that way, but theoretically that's what it is. So any money, and that's regardless of whose name the bank account is in, regardless whose name the mortgage is under, regardless of whose name is on the deed on the house or the property you purchased, as long as that property was purchased either the day of the marriage or going forward, okay? If you had purchased that property the day before, that's called separate property. So separate property deals with any assets or money, cash, earnings acquired prior to the marriage of either spouse, as well as separate property is also inheritance. So if either spouse inherits property or assets, either prior to the marriage or after the marriage, during the marriage, that inheritance, it remains their separate property. That's not something that their spouse has access to after divorce or during the marriage, really. I mean, that's a different issue, but after divorce, they do not have any right to that. So keep that in mind. So in mediation, going back to that, you will decide on issues such as property, how that's going to be divided between the spouses, as well as child issues, and child support. Child support is also pretty standard in Texas. There is a standard amount for one child. It's 20% of your net income, but net income is calculated only according to federal deductions, okay? For example, on your paycheck, you'll have your deductions for federal taxes and Social Security. That's fine. Your number after that is what they use to calculate what you would owe in child support. But if you have things deducted, for example, contributions to your 401ks or other investment or stock option, whatever it is, that is not calculated in part of your income. Okay, you have to they keep that money in basically. You cannot deduct that and then calculate the child support based on that, okay? Because that's a benefit to you rather than a tax that's taken by, that you have no choice to be taken. So 20% for the first child, 25% if you've got 2 children, so 25% total, 30% for the third, and so on. And that is, I believe now, every year or every 2 years, the Texas legislature updates. And I think now it's maybe the first $110,000 or $115,000 of income. That's the maximum. Okay, so that's the threshold. So for the first $110,000, don't take me on that number exactly. I can tell you later. But for $110,000, let's say, 20% of that. Anything you make beyond that is not calculated in the child support that you owe. Okay, and the way child support is distributed in Texas usually is through the Attorney General's office. So, you know, they will usually have a wage withholding order signed by the judge at the same time that your divorce decree is signed, and that will automatically deduct the child support that's owed from your paycheck doesn't even come into your account. It goes straight to the Attorney General's office, and Attorney General's office will then deposit it into the other parent's account. Okay. I'll go ahead and start answering questions. Sure.
So, you want to read or you want to read?
No, you go ahead and read.
How do you navigate Islamic divorce law and Texas divorce law? What trumps what from the sister's side?
Okay, as far as Islamic divorce law, I have no knowledge of it, and I can never claim to have knowledge of it. I can only tell you how Texas state will deal with that. So in my experience, the courts can treat an Islamic marriage contract as a premarital agreement, okay? As long as you can prove that both parties obviously consented to this, both parties have signed it, then you can use that in court to show that you have a premarital agreement as to how your assets will be distributed after divorce, okay? So whatever you have in the marriage contract about qaddam, akhar, all those things, you can use that to dictate how your assets will be distributed after. It's not a guarantee, of course, but it is a way to get there. Okay, that's all I can speak to on that issue, and you would have to, I suppose, speak to, yes.
In the state of Texas, is it allowed to, in both cases, divorce and or will and trust? Can you define a person to judge according to Islam, and all parties agree that this person is acceptable, and we can name him by name, or we can name an Islamic center, for example, and say you go to them and they're going to distribute or judge in divorce cases according to Islam?
So let me answer.
Executor, exactly. But without going to details, whatever that person is going to, come up with, is that?
Yes, I understand. So with family law, yes, you can, in your agreement, say that should you have a conflict or decide on divorce, that you will refer to arbitration and name the arbitrator or the specific organization, and if there is an office for Islamic arbitrators, whoever you refer to, and that's how you will proceed with the divorce proceedings. Then yes, you can do that, and then you would have to still file a petition with court for divorce, and you would have to, if there's agreement still from the spouse, then you can just go ahead straight to that, and that will act as your arbitration or mediation. The difference between arbitration and mediation is that whatever the arbitrator decides is final, okay? In mediation, it's still binding because you will come out with a mediated settlement agreement, and whatever you agree to that day, even if it's just some issues from the divorce, say you could only agree on the property, but you have not been able to agree on the children, whatever you did agree on that day is still binding, okay? But it's also, there's a temporary mediated agreement, there's a final agreement, there's different ways, but with an arbitrator, if you do decide to agree on submitting it to an arbitrator for final judgment, then yes, you are able to stipulate to that in your premarital agreement. Or you can decide that, say you already got married years ago and you still want to make sure that this happens, you can have a marital agreement during your marriage.
That's great. Same for inheritance?
Yeah, we put it in the will, and we also put it in the marital agreement too.
So basically this is much easier than Plan A or Plan B?
No, you still need to do plan.
I'm going to name an organization or a person that I trust. House.
Yeah, but
I don't have to go into details.
Yeah, but you still need to go into the details. You need to have both layers. You still need to. You need to say whose property owns what. You're gonna let the sheikh decide that? You can.
It's very much easier just to name a person or an organization.
Yeah.
They know Islam, they know the family, and that's way much easier than naming stuff. Anyhow, but both of you confirm that that's legal, that's acceptable in Texas.
I would say though that an issue that went into in probate is that if you just have a will and you say that in your will, you still have to go to probate with a judge, and the judge is going to have to sign off on that, approve of it. Okay, so you run the risk of the judge not approving that
Is
request.
there
Maybe it's not-
any reason for a judge to say no for a Muslim saying, I want an Islamic organization to take care of my stuff?
If it's not specific enough, then yes, they can, and they have a lot more authority than you may expect. So yes, if they feel like it's not specific enough and it's not dealing with all your property in a sufficient manner, and what they feel is fair, then yeah, they might be involved. So to be safe, like you said, Joseph said the other day, he had maybe a will that was not airtight, but like it should have been, and he happened to get it through. I'm not saying it will not, but from what I understand, is that you want to be more specific so that there's less chance of them changing it or messing with it.
So going back to the percentage for child support, you mentioned 20% for the first child, and then you said 30% for both, first and second?
25.
25
25 total
for both.
for both, yes.
Excuse me, the second one not.
Well, I will say that Islamic law provides a lot more for the children after divorce than Texas law does. Okay, from what I understand, you know, the father is supposed to care for the entire needs of their children, whether they are married or not. Texas law does not require that. So yes, that's a
So it's
astute
20,
observation.
25, 30.
Yes, and so on until I think the maximum is 35 or 40, and then it stops at that maximum.
So the law believes that 20% is a good percentage for one person, one child, and then they believe that 25 is enough for two. That is not so smart.
The math is not mathing, I know.
What are you getting there?
There's also, I want to make the point that just because the law says that that is the minimum does not mean that you cannot agree to something else, okay? This is just to make sure that there's a basic standard of care that is given to the children. You are able to agree on any sort of arrangement that you want. So you can always say, I'm going to give more, or I am going to, you know, make sure that I pay for all of their schooling, or I'm going to, et cetera, et cetera. You can always agree to anything, and that goes also for, excuse me, like we said, the distribution of assets in the marriage, okay? So whatever you agree on, more than likely will be approved. But this is in place for, oftentimes, you may think that you are in agreement now in the theoretical future, but when people are actually getting divorced, things happen and people change and they say different things, and so it becomes much more difficult to get to that place. So this is just ensuring that when you go to a judge and you say, I can't agree, the judge will say, what's your income? Show me your W-2s, show me your bank statements. This is the number you have to pay.
Thank you.
One more question?
Here's if a couple gets divorced but the woman and her kids don't feel safe in the same house, they don't have anywhere else to go.
So the question is, if a couple gets divorced, but the woman and her children do not feel safe, still being in the same house with the husband, but they don't have anywhere else to go, what's the solution? So there are things that can happen. So once the petition is filed, first of all, there's two options. You can file to get a protective order. So if there is a fear or a history of violence in the home between the spouses or the children, you can file for a protective order. An emergency one will take effect immediately, so that that person can no longer come near you. Also, and just sometimes it's just not that there's a fear of immediate violence, but it's obviously can be uncomfortable to be in the same home when a divorce is pending. Generally speaking, the judge will order, usually it ends up being, not always, the husband who will have to temporarily leave the home while the divorce is pending, while the mother and the children stay in the home until it's decided how the assets are distributed, okay? And then that's part of temporary orders. When I mentioned that when the petition is filed, oftentimes we come to an agreement on temporary orders, and that will say what happens while the divorce is still pending. Because things still people need to know where they're living, people need to know how the bills are going to be paid, who's going to see the children when. So those things can all be agreed upon, or if not agreed upon, you can go for a hearing before the judge while the divorce is still pending, and the judge can make those decisions for you. And so yes, the spouse will be asked to, the husband, for example, will be asked to leave while the divorce is pending, because, you know, usually the mother is the caretaker of the children, and so they would need a stable place to stay. And the standard for everything in Texas divorce law, or family law in general, I should say, is the best interest of the child. So when it, ideally, that is in our law, the Texas Family Code, that every decision made by the judge should be in the best interest of the child. And generally speaking, usually it's the mother who stays with the children in the home while the divorce is pending. And then most of the time what happens with that home is that if it's community property, it will be required to be sold and then the assets distributed accordingly. Yes?
How's custody decided in Texas?
So custody is decided as a best interest of the children. So that's literally the standard in the code. So that a lot of times if that's not agreed upon, what the judge will look at is the history of the children, who's been with the children, caring for them for the majority of the time, how old the children are. It's a very different situation if the child is still 6 months old and nursing versus a child who's 16. You know, another thing is that if custody is disputed, Texas law allows for children 12 and up to have a say in who they want to be with for the majority of the time. They still have to see both parents. It's very rare that one parent will be blocked out completely from having custody of just even temporary possession of the child. However, the judge does not have to allow that. It's up to the discretion of the judge whether or not they want to listen or hear the child's testimony, and that's always done in private chambers with the judge. It's not in front of everyone in the courtroom, just to know. But those are things that they take into account. So there's no law that says specifically the mother or the father gets custody, but it's various different factors taken into account.
I have this question, shifting gears with immigration. If, let's say, we're getting old and we need someone, help us out here, so bringing someone from overseas, just to, how can I bring non-relative someone just come here?
So they can come on something, they can come on a visitor type of visa, but eventually if you want to sponsor them, you have to sponsor them through an employment visa.
So what would be the my income criteria to sponsor someone? Like, let's say I'm not self-employed, I'm just so what would be like?
So if you're retired, your retirement income does count towards the sponsorship.
Would it qualify to allow someone from overseas?
It depends on the size of your household. So
Just two. The kids are grown up, so let's say.
So usually in a household of two, the approximate amount that you need to have is a threshold of about 30,000. So it's a good thing that you brought this up because I actually wanted to mention something like a custody agreement. Sometimes whatever you win in the custody settlement, that kind of income can also be used towards some of that sponsorship money. It's not just your earning.
But
So
I'm gonna pay, the person will come, I'm gonna pay him, pay the person, like, will you drive me around, take me to the doctor, thinking something like that. So if I bring someone as an employee for me, so that's what would be the criteria for that person?
Well, that's if you're going into, if you're planning on sponsoring them for employment. But if you're just sponsoring them just for the visitor visa, then it's about, $30,000 or so per year.
So will you get a visa? I mean, they said, no, you're not getting a visa for worship. So you think you can help out on those kind of situations?
Yeah, you can definitely get workers from overseas to come help take care of elderlies and things like that. That's been done quite often.
So how much is it for a year?
Again, it depends on the size of a household. So usually for two people, it's about like 24 to 30,000. It does change year to year.
Let's say one sister.
No, it's not how many people you're sponsoring. It's partially dependent on how many people you're sponsoring and how many people are living in your household.
Oh, in my house.
Yes.
I see.
And then if you have like dependents or not.
I see.
So there's quite a lot of.
I don't need to show immigration that how much I'll pay him. He comes just, I have to show them, right?
Yeah, you do, because you're going to be able to show that you can support their living expenses while they're here as well, on top of.
And the visa, like how long will it take? 2 years? Or?
It can be renewed for extended amount of time.
Thank you.
All right. So with that, we're going to close it up, and then you can talk to whoever you like later.
We need business cards.
I have business cards for me.
I know that you have from the sister.
Yeah, divorce is much more popular than inheritance.
We can send their contact info to the WhatsApp.
Yes.
link, so we'll-
Just one question. How about assets outside the US?
Not that assets outside the U.S., it's still going to be, yeah, please.
There's just one thing I want to add quickly, actually, because this is a question I get a lot, especially from the ladies. Some people feel like they have are unable to pursue divorce even if they are in a difficult situation because they feel like they can't afford it. Just know that when you are married, you can still file for divorce, and your attorney can get those attorney's fees and court fees from your spouse, because your assets are a community property, right? So technically, even though if you don't have specifically access to their bank accounts, that is something that the court will grant you usually, especially if you're in a situation where you have been a homemaker, you've never finished your education, you don't really have options for income as it stands, then they will help you with that. And tied to that, also I get questions about spousal support. Texas is not does not have alimony. So alimony would be money that you would give to your spouse after divorce. They do not have that. We have something called spousal support, which is much more difficult to obtain, and it is always temporary no matter what. So there are some thresholds that you have to meet in order to qualify for spousal support. One of them being you have to be married for at least 10 years, and in addition to that, there has to be other situations involved in order for you to qualify for spousal support. And like I said, even then, it's very temporary, and usually only to the point where you are able to start working and support yourself. And when I said temporary, I mean very temporary, usually just a few months, maybe maximum a year, that's it.
Sorry, one important thing I wanted to mention is a lot of times in our communities, people think that, just because your spouse sponsored you and you're here under your spouse's sponsorship, that you have to stay with them even if they're abusive. And that's not true, because there are a lot of mechanisms within immigration that you can file for where you don't have to stay with an abusive spouse. And I just hope a lot of people take it seriously, because time and time again, we see a lot of people staying in abusive relationships. So if you see anybody in an abusive relationship and they are here, on some kind of visa because they've been sponsored by a spouse, do reach out to them and let them know that they're on sponsorship.
And that would not affect the processing of the papers, right?
No, absolutely not. They can actually get green card because of abuse as well. Yeah.
That's good to know. So you have business cards you can
I actually forgot to bring mine with me, but I will definitely give my information and I am associated with the law firm.
On the WhatsApp.
Okay, on the
Jazakumullahu khairan for this insightful and beneficial